Good morning, everybody. My name is Jeremiah Welch at SDV Law. I will be acting as the host of this webinar. We're pleased to present this webinar about the Sky Mace versus Riverstone case with my colleague, Chris Ives here from Fenchurch Law. Those of you that have been keeping up on SDV developments, we now have a collaboration, a partnership with Fenchurch. So you'll likely see a lot more of this type of content from us. We're excited. Fenchurch, of course, is based in London with offices globally, and it's very exciting. And I think this type of content, the ability to talk about a decision, the Sky versus Riverstone decision out of London, the way we'd say it, it's a builder's risk case. Construction all risk, CAR, that's how they would refer to it there, but it's becoming increasingly important, I think, for folks in the US to understand how decisions in the UK and elsewhere are affecting risk. It's the same kind of risk and the same kind of construction that you would see here, and the markets that insure these things look at these sorts of claims all over the world, and what goes on in the UK and how they're looking at court decisions affects what happens here. And that interrelationship of what goes on here and what goes on there is becoming increasingly important, and therefore something that folks here, brokers, insureds, really need to get more and more understanding of. And so that's in effect what the mission is here. I'll turn it over to Chris to introduce himself, if you want to say a few things about Fenchurch, and then start running us through.
Yeah, sure. Thank you, Jeremiah. Well, good morning, everyone. I am very pleased to be here talking to you today with Jeremiah. Fenchurch, like SDV, are a firm who specialise in acting for policyholders, and I have a keen interest in builders' risk claims, or CAR claims as we call them in the UK. And yes, we're looking forward to talking to you about this decision, which is a decision by the Court of Appeal, which is the second highest court in the land in the UK, and getting into the detail with Jeremiah as to some of the differences between English law and how the outcome might be different or slightly different under US law. So yeah, we're looking forward to talking to you about it.
All right, so let's advance the slides, and Chris, you can let people know what we're looking at. These are going to be some pictures from the project that we're going to be talking about.
Yeah, sure. So this is a dispute involving the construction of a building for Sky, who are a major broadcaster. And the building you can see on the slide is their European, is a Sky office, in fact. And if we just skip on to the next slide. Sky were constructing a brand new office, here it is, which was to be their headquarters in West London, which was to house much of their main broadcasting facilities, recording studios, social spaces, offices. And what was particularly unusual about this project was the fact that it was to have a very large flat timber roof, which you can see at the top of the slide. And in fact, I think the timber roof was at one point said to be the largest flat timber roof in the whole of Europe. And the roof was comprised of these cassettes, which are those sort of rectangular wooden blocks you can see on the slide. And I think if you can flip forward one slide, we might have a slightly better picture of them. Yeah, so there they are. And if you go forward again, I think the roof was comprised of 472 of these cassettes, which were prefabricated off-site, installed on the roof, and then, importantly, for the facts of this case, prior to the permanent roofing structure being installed, these cassettes were left open to the British weather with, you might think, predictable consequences. And essentially what happened was there was, due to a design failure by one of the roofing subcontractors, there was a failure to think about and design and install a temporary roofing structure, which would have covered these cassettes prior to the permanent roofing structure being put in place. And because of that failure, water was able to get into the timber cassettes during the construction phase. And that led to a lot of the problems which we're going on to discuss. So in essence, that's the sort of nature of the project. It was a significant project for Sky, who were insured on the builder's risk policy as the employer, along with Mace, who are the main contractor, and the subcontractors. So yeah, the fundamental problems were that the water was able to get into these cassettes during the construction phase, and there were then issues with the insurers, a number of issues which we'll go on to discuss in more detail. But the fundamental issues were the extent of damage suffered under the policy and what was the meaning of damage under the policy, but also whether damage which occurred after the end of the period of insurance was covered. And we'll need to unpick that a little bit in a little bit more detail, I think, Jeremiah, as we go on.
Right. That I think is probably the major issue. Could we advance to the next slide there? Yeah, I think this is, of course, we're dealing with construction all risk, builder's risk. The question of what is physical damage was an issue here. That's an issue that will sound familiar to those of us in the US that have been following builder's risk case law development. We had a couple of cases last year where that was a hotly contested issue. What is physical damage? But this notion of damage that progresses after the policy period is probably something that folks here haven't thought a lot about. It does come up from time to time, and it's a complex issue. And we'll look at that. We'll talk about investigation mitigation costs a little bit. And another issue we're all familiar with is the number of occurrences, how many deductibles are triggered. That came up here as well. And I'll tell you, one of the things that I found very interesting reading through this case, a lengthy decision, but as somebody who practices coverage law in the United States, seeing things that were very familiar arguments and, sort of red herrings, as we call them here, arguments that the insurance company might have thrown up that don't really belong. We saw a lot of common ground there. I think so. Let's get rid of the slides for now. So I think one thing though that's important to point out in a lot of the decisions that we've talked about in the United States recently, they've kind of centered around this issue of defective construction. And in the recent South Capitol Bridge Builders and Archer Western cases that were about concrete, there was a robust discussion about defective work, defective material. And the challenge often in US cases is the entanglement of the work and the damage, and carriers looking at it and saying, I don't pay for defective work, I pay for resulting damage. And whether those things are hopelessly entangled, and does that complicate the decision or not? That didn't strike me as being a major issue here, Chris.
Yeah, that's right. I mean, happily, in one sense, because it is a very difficult issue, as you know, to determine. And I think that was mainly because on the facts of this case, as I say, we had the water ingress during the policy period as a result of the design error, and damage, as we'll go on to discuss then, had deemed to have occurred. And the policy in question had a DE5 exclusion, so that only the costs of additional design work were excluded. So that's obviously one of the most favourable forms of design exclusion from the policyholder's point of view. And it was common ground that there was cover under DE5, basically, with the insurers, so that the issue of resultant damage, whether the damage resulted from a defect, didn't arise on the facts.
Yeah, and I think too, the defect, as you said, the design, the plan, that did not involve a temporary roof. I think it's fairly easy then to say, okay, that is my defect. That decision about how to construct the roof and the lack of a temporary roof that then results in exposure to water. Water gets in, causes damage. I think under our, whether it's leg 3 or cost of making good, the various different faulty workmanship exclusions here, you probably have an easier go of it because you do have that clear separation between what's defective and what's resulting.
Yeah, exactly. And I think just looking at sort of mapping out the issues really between insurers and the policyholders. So the insurers accepted that some of these cassettes had been damaged during the period of insurance, but based upon their argument as to what constituted damage. But they were saying that where the policy, as in this case, covered damage occurring during the period of insurance, i.e. during the construction phase, their obligation was limited to repairing the damage which they said had occurred during the period of insurance. And to put that in sort of financial context, the insurers were saying, I think, that the cost of repairing that damage was approximately £30 million, so sort of $40 million US, two days ago at least. Whereas on the other hand, the Sky and Mace were arguing that that wasn't right, and that offer or that measure of loss didn't fully compensate them for what had happened. And the policyholders were saying that, in fact, their definition of damage was wrong, and that, in fact, more of the cassettes than the insurers said were damaged. And we can look at this in a bit more detail. And so there's a big argument around that. But also where cassettes, where there'd been what was called developmental deterioration damage, i.e. Water ingress during the policy period, which had wet the cassettes, and that wetting had, after the period of insurance, then caused decay or rotting or spread to other timbers after the period of insurance. The insureds were arguing that that progressive damage was also covered because it resulted from damage, wetting, that first occurred during the period of insurance. And there was a huge dispute around this, as we'll get on to discuss. And the first instance, court found against the policyholders on this key point, and the Court of Appeal came to a different conclusion on very interesting grounds as well.
Yeah.
So I was just going to say, so just in terms of the financial difference between the two parties' positions. So it's £30 million, I think, from the insured's point of view. From the insurer's point of view, but the insureds are saying the estimated cost of repairs were in excess of £100 million, and that was basically the difference between their arguments on damage and the progressive damage.
So the insurer was effectively saying, I want to go back in time and measure what the cost of repair would have been had this been dealt with at the end of the period of insurance, effectively. And that's the measure of covered damage only, right?
Yes, exactly. But actually, that was quite an artificial position for the insurers to have taken in one sense, because as at the end of the period of insurance, it was not known the extent of the damage. This was a very complicated issue. And some of the timbers, the cassettes were wet, but the extent of the damage wasn't yet fully known. It hadn't been remedied, obviously, and it was continuing to deteriorate in some respects. So, and in fact, that's one of the difficulties that the insureds faced. They were unable to carry out a remediation scheme as at the end of the period of insurance because they didn't know the extent of the damage. And what's actually quite interesting, another interesting facet of this judgment is that the insurers didn't criticise the policyholders for failing to mitigate. So very often in a situation like this, there'll be arguments from the insurers that the insured should have done something to mitigate the loss, or could reasonably have done something to mitigate the loss. And those arguments weren't seemingly available to the insurers on the facts, because the insurers basically accepted that this was a complicated problem and there wasn't an easy solution.
Yeah,
As at the end of the period of insurance.
yeah, I think that's a sequence that makes it a little unusual for us. I mean, you would normally think that whatever the dispute is would have been long since resolved, and that the owner would have said, this gets fixed during construction, and I'm not going to accept the project until it's done, and the builder's risk policy gets extended, and all of this is so that when you get to trial, it's all looking back at something that's done and over. But yet in this one, that wasn't the case. It was still the method of repair was still yet to be determined when it was tried.
Yes, exactly, and that was still hotly contested by the time we got to trial. And on the period of insurance being extended, that's obviously possible in the UK as well, but it didn't happen on the facts of this case, and we don't quite know why that is the case. But one presumes it's because the builders' risk insurers didn't want to extend the period of insurance, thus leaving them exposed to having to pay progressive damage, which occurred even on the facts of that, even with the period of insurance having been extended. In other words, they wanted to perhaps preserve the rights to run the arguments that they eventually ran a trial and before the Courts of Appeal. But yeah, in another world, you could perhaps have foreseen a situation where the period of insurance was extended until all these issues have been resolved.
And it's interesting because I think this could be, a sign of what's to come, because I know here in the US, being able to extend the builder's risk policy to accommodate a delayed project is becoming more and more and more of a challenge. And I think you could have the same fact pattern here. You could have a situation where there's a known defect, known problem, a course of construction related problem, but perhaps it's not structural, and the owner can go ahead and take occupancy and start using the asset while we figure out what the repair is going to be. And you can wind up in the exact same set of facts that we see here. I think it's very possible.
Yeah. Yes. I think obviously in a situation where the cost of repairs can be identified and everyone knows what they are and how to remedy them, then in those circumstances, it will be generally easier to persuade the insurers to extend the period of insurance. But where there's a big question mark over the extent of the damage, then it's obviously going to be more difficult.
One thing that I noticed, back to that topic of damage, the court was going through the different positions advocated by each party, and the court noted that the insurance company's expert had said damage. So he's going in to testify about damage and cost. He says damage to me as an expert means loss of structural integrity. Nothing short of loss of structural integrity is damage. And that struck me because, one, I think obviously that's incorrect, but second, that we do see that same pattern where the expert is really making a coverage determination, right? It's it's odd for an expert to take that position because obviously that supports a coverage argument that there's no damage, and so they sort of alter their technical definition of what they're looking for. It's
yeah. Perhaps, if I may say so cynically, asking that question or addressing that question when it's been posed by the insurers' lawyers, perhaps. But yeah, absolutely. What the expert says is the definition of damage. It isn't the relevant issue. That what is the meaning of damage will turn upon in the UK, and I'm sure in the US, what the policy says and what the law says, and the common law. And in this case, the arguments on damage were to do with whether, as you say, the insurers were saying only those cassettes where the structural integrity has failed are damaged. And the insured said, well, no, that's not right, based upon long established common law principles, some statutes as well, some criminal statutes actually, which refer to damage in the UK and the meaning of damage. And in fact, the dictionary definition, an item it can be damaged before the structural integrity is impaired. If there has been an impairment to the physical change to the property insured, which impairs the commercial value from the perspective of the policyholder. And that was nothing new in the Sky case in terms of extending what the definition of damage means or changing those common law principles. But based upon those principles, the lower court and the Court of Appeal concluded that those cassettes which were wet and where if they were not dried out, i.e. the wetness was not remedied, and they would eventually become structurally impaired, were damaged during the period of insurance, even though that structural impairment hadn't occurred during the period of insurance. And I think that's not particularly controversial or surprising from the perspective of a UK coverage lawyer. That's the result we would have expected. It's a fairly orthodox decision. And if you think about it from the point of view of the policyholders, the mere fact that the cassettes were wet and they would eventually need replacement, or they would need drying out or repairing, that's a cost that would have to be borne by them, and therefore you're well on the way towards proving that damage has occurred in accordance with those kind of classic principles.
Yeah,
I think you get the same. You get the same result in the US. I think.
I think so. I could imagine a carrier here saying the mere presence of water isn't damage because the consequence, the structural impairment, the swelling, the rot hasn't happened yet. But then, as you think about that argument, both what you said and also that, well, look, if the water is there, I can't just leave it there. I have to do something to get it out, or it's going to decompose. And so that state of being wet needs to be repaired. It needs to be. So in other words, if you knew it in the moment what had happened and could do something about it, you'd have to incur cost. You'd have to interrupt the schedule. You'd have to do some kind of a drying out process. And so therefore, there is a condition that needs repair. And I think that's another way of looking at it, and then reassuring yourself that, okay, yeah, this is damage. It doesn't need the progression to say that there's damage during the policy period.
Yes, absolutely.
And do you think that would have been the same? I mean, if the court had said, because I understand that there was some structural damage to some of these cassettes during the period of insurance, but let's say that hadn't been true. Let's say it was just wet and we knew what would happen afterwards, but it hadn't happened yet. It's just water. You think the court would have said the same thing?
Yes, probably. I think it's perhaps just worth emphasizing that this was a policy which covered it against the risk of damage occurring during the policy period, resulting from all risks, any risks. So it's what we in the UK would call a damage occurring policy, as opposed to an insured peril occurring policy. Now, that might be quite a fine and artificial distinction in many cases, but it's not necessarily always going to be the case that in a damage occurring policy, water ingress equals damage at the same time. Now, actually, on the facts of this case, the court didn't draw a distinction between the two. Once the timbers got wet, that was the physical change of condition, and the position from there on in might have deteriorated and developed. But the point at time at which damage occurred was when the water ingress occurred, basically. But yeah, it's not hard to see how on slightly different facts there might be the insured peril might occur at a different point in time than the damage.
It's one of the things that this sequence made me think of here, somewhat in response both to the challenging market conditions, but also some of these recent decisions. Some of the insurers in the US are pulling back these leg 3, leg 2 endorsements and replacing them with what many people will refer to as cost of making good. But the point being, in those cost of making good endorsements, there's very often a provision that says that they'll only cover damage caused by an ensuing loss. And you would say, okay, here we've got a clear example of ensuing loss, because you'd say, okay, again, my defective workmanship or design is the temporary roof, and that resulted in exposure to rain. The rain caused damage. There's my ensuing loss. But now we're starting to see carriers argue that, well, no, if you don't cover the roof, rain coming in is and they'll say the natural and expected consequence of the defect, and therefore not covered. It's not something different, which, I think we're starting to see that pattern here more and more. And that obviously leads to the question, okay, well then what is covered? If this sequence, right, if the resulting damage of the rain is the defect, then, I think we're really stretched to find what fact patterns could in fact lead to coverage. So let's talk about what I think is probably the most challenging piece of this for folks in the US to follow, is the way the court handles the basic question of what is the insurance promise, right? Talk to us a little bit about that, this idea of the promise that the peril won't happen in the first place.
Yeah, sure. So the first principles under English law, an insurance policy is obviously a contract where the insurer promises to do something. So the question is, what is the insurer's primary obligation in relation to an insurance policy like this one, which says we will indemnify you if damage occurs during the period of insurance? Now, what is long established under English law, but not widely understood outside, the insurance specialists perhaps, is the fact that the nature of the insurer's promise is to hold harmless. Now, what that means is that the insured is contracting on the basis that, the insurers are contracting on the basis that the damage or the insured peril, if different, will not occur. Now, that can be quite difficult to get your head round, I think, potentially, from a lay perspective, because the insurer can't do anything to prevent damage occurring. It's not on site. It's not in control of the design process. There might be, conditions and things it can include in the policy to try and control the behavior of the insured, but it can't fundamentally prevent the damage occurring, and it can't therefore prevent itself from being a breach of contract, basically. So, as I say, some people have a sort of issue with that fundamental concept. And I think it's different in other jurisdictions around Europe, and I think in the US as well. So in the UK, in English law, where the insurer is in breach of contract, That's his primary obligation, to prevent the damage from occurring. Under ordinary common law principles, the insured are entitled to damages to put them back in the position they would have been, but for the breach occurring. So to put the innocent party back in the position it was before the damage occurred, basically. So the decision that the Court of Appeal reached in relation to progressive damage was rooted in this understanding that the nature of the insurer's promise is to prevent the damage occurring. And once the insurer's in breach, you then look at the loss which flows from the breach. So I think that is quite different from the US, and maybe you can explain how it's different in the US.
Yeah, I think there are two things really there that would strike anybody that deals with contracts in the US. I mean, the first sort of golden rule here is that you look first to the language of the policy, the contract, and if that language is unambiguous, that's all you look at. And so this notion of starting with a position that says, well, it's the nature of the insurance contract to do this, before I even look at what it says, that when a court says something like that here, red flags go up and everybody gets excited and they say, no, you can't do that. That's a sign of, bad judicial analysis. You only get to intent or, sort of general notions about what kind of a policy this is supposed to be, if something about that policy is ambiguous. And I think that to me is the key to looking at this and saying, okay, would this in fact be a different outcome in the US? So that initial approach, is it language or is it intent, is different here. But then the notion that the insurance policy is a promise that the peril won't happen is a very novel way of looking at it here. We would say, no, it's a promise that if the peril happens, I will do the following. And I think that's what the insurers argued, right? Here they tried, I think in the case, they started off trying to make that argument. No, look at what the policy says. We didn't promise to quite make you whole.
Exactly that. So superficially, perhaps, exactly, the insurers are saying the policy says we will indemnify in relation to damage occurring during the period of insurance, and that what could be clearer? It means we will pay irrespective of damage which occurs during the period of insurance, and nothing that results thereafter from damage first occurring during the period of insurance. I can see how, from a US perspective and an insurer's argument, there is a superficial attraction to that argument, and it was accepted by the lower court. What's interesting actually is that the judge in the lower court, I don't think, was an insurance specialist, whereas by the time you get to the Court of Appeal, you have a specialist insurance lawyer looking at it. And when you look at it through the lens of those ancient legal principles that we have in the UK in relation to insurance contracts, he reaches a different decision. And just on that, it's probably worth flagging, because I think this is another difference that we have over here in the UK, that a lot of our insurance law is rooted in marine insurance law from the times when British ships were sailing around the world and they were crashing, and the courts had to figure out legal principles in the 17th and 18th century. And one of the key principles which this decision is rooted in relates to a marine case, I think, from 1850, where which established what's called the death blow principle. So it's not quite not directly relevant to the builder's risk market, but where an insured ship was grounded, damaged during the period of insurance, but then was taken back to harbour. Repairs were carried out to see if it could be salvaged, and the extent of the damage wasn't discovered until and it wasn't finally determined that it was damaged until some period after the period of insurance expired. And the courts said, well, nevertheless, the insured peril has occurred during the period of insurance, the grounding, and therefore the damage which ensues, even though that only results thereafter, is all covered. And that was I think the first case which established this principle that loss resulting from the breach of contract in an insurance policy is covered. Subject, of course, to anything contrary in the policy language, and subject to the common law rules on whether that loss is foreseeable, whether it's been caused by the breach of contract, whether there's an intervening cause, whether the insured have mitigated their loss. There's all sorts of principles that need to be considered, but the starting point is that loss which is caused by a breach of contract is covered, or is in scope to be covered, which actually it's a really useful point and principle for us in the UK to keep in mind, because from a claim scenario, obviously you will need to be considering the policy and what the policy says. But if you sort of reimagine that, actually the loss that you can potentially recover from a policyholder's perspective is not necessarily restricted or only going to be covered if it says it's covered in the policy. There are common law principles which allow the policyholder to potentially argue for a greater level of indemnity. So yeah, that's potentially very, very useful for our kind of client's point of view.
Yeah, I did see there that the court pointed out that, yeah, I think it said something to the effect of if the insurer is seeking to depart from the common law rule, it has to say it more clearly, which implies, and of course I look at this and I say, right there in the coverage grant, it references the policy period. How much clearer do you need to be? But it implies that, I suppose, if they'd had an exclusion for damage after the policy period, perhaps that would have been enough. Do you think?
Yes, exactly. So the importance of the policy period here is that it dictates the period within which the breach of contract has to occur, whatever the breach being the insured peril, whether it's water ingress or damage, whatever is the thing that is insured under the policy. If that takes place during the period of insurance, then the insured is off first base, potentially, in arguing that it's within the scope of the insuring clause. And yeah, you can perhaps see how, from the insurer's point of view or from a lay perspective, as we've said, the outcome is perhaps not on all fours with the literal wording of the policy. But equally, I think, I totally agree that if the insurers wanted to definitively exclude progressive damage occurring after the end of the policy period, they could have done so by more clearly wording the insuring clause, by adding an exclusion, therefore the outcome would have been very different. I mean, that begs the question, I suppose, what the response of the builders risk market in the UK will be, and I don't know the answer to that yet. I think obviously they would love to exclude progressive damage if they could, but clearly insureds and their brokers would want to cover progressive damage, and there is I think a real need for them to be able to do so, because if we just take the facts of this case, for example, if progressive damage was clearly excluded, such that we reach the end of the policy period, the extent of the damage isn't clear, the insureds don't know what to do in terms of remediation, they will have to carry out those further investigations and repair work at their own cost. They are most unlikely to be able to pass that risk on to, a building insurer in relation to the completed building.
Right.
Because the building
insurer, no loss, right? I mean, under these facts, if they had gone into a new carrier's policy period, whether it's property or even general liability, any way you can think of it, that carrier would say, well, that's a known loss. You knew about this. I don't cover that.
Yes, and and the loss results from damage which first occurred
Right.
prior to our period of insurance, during the construction phase. So in essence, the insured would be left uninsured in these circumstances. So we're probably not going to get a clear view on this in the UK for a short period of time, because there's the potential for the builders risk insurers to appeal the decision to the Supreme Court. And I guess everyone will be waiting to see the outcome of that permission application, and then of any subsequent appeal before deciding whether policy language needs rewriting.
Yeah, this is interesting. Can we put that slide on the screen that has the comparison of the two policy languages here? Yeah, I wanted to show the audience this. I think what we're sort of circling around is differences in language and whether there would be a different outcome in the US. And I confess, it took me several readings and a lot of thought about this to try to sort of crystallize down to what I think might really turn the outcome here. So if you look at that coverage grant from Sky, you'll see there, subject to the terms of insurance, indemnify the insured against physical loss or damage to insured property occurring during the period of insurance. There it is, right? So in the Sky policy, there's an embracing of that period of insurance in the coverage grant. And I think a US court would very likely look at that and say, I don't need an endorsement or an exclusion. That's telling me that I only cover damage during the policy period. And it might be more difficult than in the US to argue that you get any damage that continues afterwards. I think in the US, you'd be thinking about arguments that would say, well, the scope of repair that was necessary based on what happened during the policy period didn't change. And so you'd be trying to get experts and talk about the idea that, yes, I fixed it afterwards, but the scope of the repair didn't change. Now, under the facts of Sky, I think that would be difficult. But then if you look over at the Archer Western, so big recent builders risk like 3 case, and you look at the coverage grant from that policy, it doesn't have any reference to the period of insurance at all. It just says we cover damage to insured property. And I think that in the US, it's a lot of people forget this, I think, but it's true that even if you're after the policy period, the builder's risk policy period, and it's true that you now know that there was damage during the policy period, you can go back to it. It's still there, and it does its job. But there doesn't really seem to be a mechanism in the typical, and I looked at some others too, in the typical US builder's risk policy to deliberately try to confine the coverage to the policy period. And I think that's the important piece. I think we get to the same place in the US as what happened in Sky, but specifically because of this difference in the coverage grant, we don't have that limitation to period of insurance. And you and I, Chris, I remember before we got online, we're talking about why that might be. And perhaps it's because of what we just talked about. It might be that the practical impossibility of insuring elsewhere damage that is begun during the builder's risk policy period.
Yeah, it is really interesting, isn't it? So you're saying that on the facts of the Sky case under the Archer Western policy, because it's not limited by the insuring clause to damage occurring during the policy period, you'd more easily be able to contend for coverage in relation to progressive damage.
And I think I think we think about it here as more about whether the peril happened during the policy period. And if the peril happened and the damage all relates to that peril during the policy period, then the policy covers it.
Yes. on the Archer wording, but on the Sky wording, that argument probably wouldn't cut the mustard. Yeah, I'm just looking at the Archer wording, and I wonder whether the insurers might try and argue that it obviously covers property of every kind and description intended to become a permanent part of the fabrication, assembly, installation, erection, or alteration of the insured project. And once it becomes part of the insured project, does that delineate the end of the policy period? Probably not, because the insured project will be the project works. Yeah.
Yeah, I think that's right. I mean, I think that's more about the idea that it's comprehensive, and that, you know, typically we'll say, well, if it was included in the construction value, then it's covered, and it could be sitting there waiting to be installed. It's still covered. But I have heard from time to time, insurers will argue, well, no, that's outside the policy period. And that does happen. And I think, you know, here, absent some clear language in a US policy to say we don't cover damage after the policy period, I think we're probably in a strong position to say, no, if the peril happened during the policy period, then any resulting damage is covered. And we don't have to contend with that argument that the insurers raised in Sky about the coverage grant. I think that difference is significant.
Yeah, I agree. I mean, if obviously given the choice, you'd in the US, you'd clearly want the Archer wording, and I don't think I've seen similar or equivalent wording in the UK as Archer, and that's because the insurers, as I said earlier, are always going to want to dictate the period within which damage occurs, to try and, you know, limit the period that they're on risk for, effectively. So yeah, I don't know if the Archer wording is an outlier, or is it remotely
It doesn't
unusual,
seem to be. This, you know, each one's a little bit different, but I didn't see any that had policy period in the coverage grant. And there may be some, but I think, you know, perhaps a takeaway for folks in the US is to say, you know, keep your eye out for that. That could be an important issue. Because I certainly think that if you had the Sky wording in the US, that you would see the same arguments here that the carriers made there. And it might in fact get some more traction. So let's take that slide off the screen. So we've got a few more minutes. Let's talk about the issue of the coverage for investigation costs. It's probably a relatively simple issue, so we can go through that quickly.
Yeah, so as you say, this was to do with in order to investigate the damage, whether damage had occurred, the insureds carried out investigations, and they took steps, what was called in the judgment in terms of lifting the lid, so raising the roof in various parts in order to assess the extent to which damage had occurred to the cassettes underneath. And the issue was whether the insureds were able to recover those investigation costs, even where the investigations had not revealed damage. And there was no specific cover in the policy wording in relation to investigation costs, which is slightly unusual, perhaps, and something that we may change in the future. But at first instance, the court found that those costs were not recoverable where damage was not discovered. That point was appealed, and happily from the policyholder's point of view, the appeal was successful. And the reason the policyholder succeeded on that point really goes back to the analysis of the nature of the insuring clause and the contract and what the insurer is contracting to do. Because where you have a contract and that contract is broken, the innocent party, whether this is an insured or an innocent party to an ordinary, commercial contract, is under a common law duty in the UK, and I think it's the same in the US, to mitigate their loss. So you can't just sit there as the insured and do nothing and sit back if there are steps that ought to be reasonably taken to mitigate the loss. So that's the first sort of rule of mitigation. And the second rule is that where those reasonable steps are taken, the insured or the innocent party is entitled to recover those costs, subject to anything contrary in the contract. So the mitigation costs flow from the breach, from the damage having occurred in the first place, and provided they are reasonable, then those costs are recoverable. So that's it's another really handy finding from the insured's point of view, to be able to argue for mitigation costs, and that's regardless of whether damage is discovered or not. Because if you think about it, you don't know if damage is there unless you have a look for it. So why should coverage be determined by whether damage is identified or not? It's a slightly perverse argument.
Yeah, I think we'd have the same result here. I don't think, the cost of investigating to determine the extent of the repair, I don't think there'd be much controversy here that would be covered. Although I think here you might say that is the cost of repair, like assessing this is integral to the repair itself. Because here you might have sublimits for mitigation, let's say. Yeah. But here I think this particular cost might not be considered mitigation. It might just be considered part of cost of repair. Yeah,
and I think that you're quite right, actually, that was also a factor in the Court of Appeals reasoning in terms of granting coverage.
And then, of course, there's the argument that, we tend to see a lot, but it tends to not go very far, is that they said every cassette is a separate event, and meaning they want to charge a separate deductible for every single one.
Yes, yeah, exactly. So I think the deductible was £150,000 any one event, and the insurers argued that every cassette which was damaged triggered a separate deductible. And if that was the case, then a large chunk of the loss would have been, uninsured. And that was given fairly short shrift by both courts as an argument, because any one event, is classic aggregating language. An event is something which happens at a particular time, particular place, in a particular location. And the court was happy to conclude that the decision not to use the temporary roofing structure, which would have prevented all this happening, was an event for the purposes of that clause, such that one event, one deductible. So again, that is a pleasing outcome for the insured, but the one we would have expected, I think, most of us.
Right. And I think we would get the same result here. Courts here tend to talk about common cause if there's a single cause. And I think they would, here they'd either look to the decision or the lack of decision to install the temporary roof, or they might say rain is a common cause. But either way, they would say this isn't separate events. This is a single event. And there wouldn't be much controversy. Now, this case is on appeal, though. What are the odds?
Yeah, so
changes there.
The insurers need permission to appeal to the Supreme Court, which is the highest court, and that permission, I think, has been refused once, but they have a second bite at the cherry. And if they get permission, the Supreme Court will obviously consider this, and permission is being sought on the basis that the nature of the law around the insurer's promise needs to be looked at by the Supreme Court. So it would, if permission was granted and the insurers were ultimately successful, I'd have to relearn everything I know, basically. So we wait to see.
Okay. So we've gotten a few questions in the chat, and we probably only have time for one, maybe two, but one that came in that I think is an interesting question to me and shows that people are paying attention to this issue of US versus UK. They ask how the burden of proof worked. So who had the burden to show damage versus not?
Who had the burden to show damage?
Yeah, in other words, I think what they're saying is, did the insured have to prove that there was damage, or does that idea of the the insurer being in breach when the peril happens, when the insured peril happens, does that mean the insured has to prove, or the insurer rather has to prove that there isn't damage? You know?
No, so the burden of proof initially would be on the insured on a balance of probabilities basis to show that damage had occurred, because that's the insured peril. And then, yeah, what if and when it can do that, then it's into the insuring clause, and then the parties will look at the exclusions, etc. But yeah, the burden initially would be on the insured.
Okay, so that flows the way we would expect it to here. Now there's a question about the relationship, and see, I knew this would come up. They're asking about how the what do you call it on the construction all risk policy? There's the extension for a year afterwards. The LDI, is that right? This idea that there's another year of coverage for defects after the builder's risk period ends.
Yes, that's right. So it's standard in the UK for the builder's risk period of insurance to run for normally 12 months after practical completion. And that is because the contractor might be back on site during that period and might be carrying out sort of defects works. Now, I think that's different than the US, is it? The period of insurance will always end at practical completion.
Yeah. The policy. I mean, it is an interesting question because it's sort of because going through this exercise, we see there really isn't something in the policy that says when coverage ends. If you kept renewing it, you know, what would happen? But the practice is certainly that once you reach either, you know, substantial or final, and I always say keep it going until final, but that at final completion you would drop the builder's risk policy and transition to property insurance. And then if there's a defect, you know, it's either a warranty obligation or it's a general liability problem. You'd make your claim against the party that did the defective work, and they would rely on their insurance to defend and pay it. And you don't have this this extension on a builder's risk policy. It's but that really didn't have anything to, and I think if I'm right, that extension doesn't belong to everybody. That's an owner only coverage. Is that right?
It doesn't belong to everyone. I missed that bit, sorry.
It's as I understand that that extension after the end of the construction all risk, it's a coverage that's available only to the owner. Is that right? Or is it also the
yes, exactly right. And that's because the contractor has handed over the works on completion. It no longer has any interest in the work. So to the extent there is damage to the works during that period, that will be a claim which can be brought by the owner. Mm-hmm. Exactly right.
Right. So I think the bottom line is that's unique to the London market or European market, and doesn't really function the way people think of it here. It's not as if you're just getting a full another year of traditional property insurance. It has some limitations. But that didn't really affect the outcome here in Sky.
No, not really. The court didn't distinguish between damage occurring pre-PC and during the defects liability period. But again, it's another interesting difference, isn't it, as to why the market is developed in different ways.
Indeed. So we're at the end of our time period. You know, Chris, thank you very much for taking the time to walk through this decision with us. I think it's really important. It's a really interesting decision, and I think our audience probably benefited a lot by that.
Well, thank you very much for having me on. It's been a pleasure to speak to you and everyone online as well. So thank you very much.
Thanks, everybody. We'll see you.
Okay. Have a good day.